Dear colleagues, it's my great pleasure and honor to be with you today and to have this opportunity to share some views on state succession. The state succession is defined as, and I quote, the replacement of one state by another in the responsibility for the international relations of territory, unquote. The replacement may occur in different ways as secession, unification, dissolution, adhesion, and so on. The international law of state succession governs some effects and consequences of the replacement regarding international treaties, state property, archives, debts, acquired rights, nationality, and other matters. International arrangement of the effects and consequences depends partly on the type of replacement. The first of many problems of the law of state succession is that the types of replacements cannot be precisely defined. It may happen, and it happened in practice, that concerned states differently qualify the replacement. The FR Yugoslavia and other Yugoslav republics disputed almost 10 years whether disintegration Yugoslavia was a series of secessions, as the FR Yugoslavia claimed, or dissolution, as other Yugoslav republics asserted. The fact was that some Yugoslav republics successively declared and acquired independence during 1991, 1992, and that Montenegro and Serbia remained then together under named FR Yugoslavia, declaring continuity with the Socialist Federal Republic of Yugoslavia. The international community was divided about the issue. Some countries accepted the claim for continuity, but others opposed. The United Nations and the International Court of Justice did not take a clear position. The FR Yugoslavia was excluded from work of the General Assembly and the Economic and Social Council under pretext that its claim for continuity was not generally accepted, but Yugoslavia remained on the list of members of the United Nations, and having been asked to pay membership fee, Yugoslavia was paying the fee. The International Court of Justice was aware of certain difficulties regarding status of the FR Yugoslavia in the United Nations, but treated Yugoslavia as a member state. After political change in Serbia in 2000, new government applied for a new membership to the United Nations and relinquished thus the claim for continuity. In the meantime, a mediator in succession negotiations, distinguished British lawyer Sir Arthur Watts, qualified disintegration as break up. In spite of vigorous opposition of some former Yugoslav republics, which invoked another qualification used in resolutions of the Security Council, and it was dissolution, Sir Arthur remained at his qualification, which was at the end inserted in the agreement on succession issues signed in Vienna in 2001. The agreement states that state succession was arising upon the breakup of the former Yugoslavia. Notwithstanding atypical qualification of disintegration, the legal arrangement in the agreement corresponds to the effects of dissolution. Another recent succession occurred also in fog of terminological confusion. 11 Soviet republics, including Ukraine, agreed in Alma-Ata in December 1991 that the Soviet Union dissolved and ceased to exist. At the same time, they agreed that Russia continued membership of the Soviet Union in the United Nations and in international treaties. 30 years later, at 11th emergency special session of the General Assembly, representative of Ukraine, a country victim of aggression of Russia, questioned legitimacy of the presence of Russia in the United Nations, challenging thus that Russia has continued the membership of the Soviet Union. After 30 years of silence, it was too late to object against continuity. However, the Alma Ata arrangement of 1991 has not been fitting to the solution of state. It might be proper for secession if a predecessor state ceased to exist, as 11 republics agreed. Its continuity should not be possible under international law. On the other hand, secession leaves a predecessor state in life and it continues its international rights and obligations. The international community and the United Nations accepted by silence the Alma Ata arrangement, according to which Russia has continued the membership of the Soviet Union in the United Nations and in international treaties. These introductory remarks illuminated, I hope, importance of precise definition of types of processes underlying succession, subsidiary character of the rules on succession, and relevance of acceptance by third states, a legal qualification of the processes underlying succession. The law of state succession is important. National economies, commercial entities, individuals have lost many benefits due to inability or unwillingness of all former Yugoslav republics, including then the FI Yugoslavia, to settle quickly succession issues. Consequences of a tragic armed conflict might have been much better mitigated by swift solution of succession issues. After 10 years of negotiations, they signed the agreement on succession issues, and I quote, "in the interest of all successor states and their citizens, and in the interest of stability in the region and their mutual good relations," unquote. No doubt that the agreement serves the stated interest. Unfortunately, some parts of the agreement, which are of particular importance for individuals and commercial subjects, have remained unapplied or partly applied. The mission of the law of state succession is thus to facilitate normal life of nations, local communities, and citizens after the replacement of states in their responsibility for the international relations of territory. The mission is important always, and in particular in cases of contested succession. In spite of this important mission, the state of international law in the area of state succession is not satisfactory, and it is not comparable with other fields of international law. There are more reasons for that, and in particular, ambiguous position of states regarding the law on state succession and specifics of the practice of the state succession. The attitude of states towards the law of state succession is ambivalent. It seems that they have been interested for consideration of practice of state succession and for codification in development of corresponding rules, but they are not willing to bind themselves by general treaties on state succession. The topic of state succession have been on the agenda of the International Law Commission of the United Nations almost over all period after the Second World War. It would not be possible without consent and support of member states. They have been thus obviously interested in the matter. The work of the Commission resulted for the time being in 2 universal conventions and a draft of rules. The Commission is working now on a new set of rules on state succession regarding state responsibility. The 2 conventions were adopted in the conferences in Vienna in 1978 and 1983. The first convention on succession of states in respect of treaties entered into force in 1996, and it was ratified by 23 states. 7 states ratified the second convention on succession of states in respect of state property, archives, and debts. 8 ratifications are missing for entering the convention into force. The Council of Europe Convention on the avoidance of statelessness in relation to state succession was adopted in 2006 and entered into force in 2009. Until now, only 7 states ratified the convention. It is obvious that states are not willing to bind themselves in advance by general treaty rules. The succession is by itself an unwished matter for existing states. States believe that they will not be affected by succession, and if they would be affected, they prefer to have some latitude in resolving problems. On the other hand, state succession is not an everyday event. It happens from time to time, mainly in large historic waves. The last wave was historic transformation of socialist political systems into civil political systems in Central and Eastern Europe. Before that, a long-lasting wave of decolonization brought a lot of succession. The practice of state succession has not been continuing, neither consistent. Particular historical factors, especially political factors, shape specific solutions. Indeed, the practice of state succession has not become a fertile ground for creation of international customary law. International courts and tribunals recognized small number of rules on state succession as customary rules. That does not mean that state succession is tabula rasa. There are fundamental principles of international law and general legal principles that substitute missing special rules and guide states in searching solutions. Principles of sovereignty, territoriality, equity, and reasonability are of particular importance. International human rights law has been getting a prominent role in some matters of state succession. Besides occasionality and inconsistency of state succession, there are certain continuing commonalities which, in combination with principles, may be a reliable guidelines. I would now turn your attention to some international arrangements of effects of the replacement of states in their responsibility for the international relations of territory, and begin with succession of states to international treaties. The effects depends on the type of replacement. They are not equal in cases of unification, secession, adhesion, or dissolution. Some provisions of the 1978 Vienna Convention on Succession of States in respect of treaties reflect customary rules. The International Court of Justice confirmed that Article 12 of the Convention, according to which succession does not affect territorial regimes established by international treaties, has a status of internationally customary rule. Having in view international law as a whole and jurisprudence of international courts, it would not be very much difficult to prove that Article 11, according to which succession does not affect international boundaries, also has become a generally accepted customary rule. These two provisions and the rest of the Convention show that the Convention tries to provide security and certainty regarding treaties as well as certain historic justice. Besides the two articles, the Convention tries to provide certainty in treaty relations by the concept of automatic succession. The automatic succession means that the treaties of a predecessor state automatically continue to oblige successor states and to apply on their territories. The exception based on historic justice was made regarding colonies. As the colonies were not represented in internal processes of conclusion of treaties by metropoles, now, when they acquired independence, they should be free to decide in which treaties of metropoles they will enter. The Convention provides thus for colonies so-called clean slate rule. Unfortunately, states did not accept the concept of automatic succession, no matter whether they had opportunity to participate in the decision-making process regarding conclusion of treaties as members or parts of a predecessor state, they prefer freedom to decide to what treaties of predecessor state they will enter. The human rights law may, however, limit this freedom. The European Court of Human Rights considers that new successor states are automatically continuing the European Convention of Human Rights. There are certain indications in judicial practice that automatic succession to human rights and related treaties might be accepted as a general rule. Thus, international development imposes a new balance between the freedom of states to contract and the general interest of international community. State succession to property, debts, and archives is governed by the 1983 Convention. The fact that the International Law Commission had been working on the subject 13 years clearly speaks on its complexity and volume. The division of state property, debts, and archives is of great importance for the beginning of life of new successor states or continuation of life of a predecessor state. The Convention has not yet entered into force, but the European Court of Human Rights remarked that the Convention might reflect customary law. It might be correct only for some provisions. The Institute of International Law adopted the resolution on succession to property and debts in 2001, wishing to refresh the provisions of the Convention by practice of disintegration of Czechoslovakia, Soviet Union, and Yugoslavia. The resolution expands the scope of the rules on state succession to private law aspects and specifies some rules regarding the succession to property and debts. The general principle is that state succession does not touch acquired rights of individuals or private bodies. The 1983 Convention, is restrained regarding the matter, declaring that it does not prejudice in any respect any question concerning rights and obligations of natural or juridical persons. The resolution of the Institute of International Law from 2001 took positive approach, declaring that the successor state will, insofar as possible, respect the rights of private persons acquired in the legal order of a predecessor state. One of many painful matters of state succession are effects of the succession to nationality. The guiding principle emerged from a long-lasting practice is that nationality of population on a territory follows the destiny of the territory. The principle has been qualified by the right of option. Double nationality and policies of extraterritorial naturalization have been also used in circumstances of succession. One of good aspects of Yugoslav succession is that the successive states have been tolerant concerning double nationality. Having in view that a general purpose of the law of state succession is to facilitate normalization of life after territorial changes, and in particular traumatic changes, this review will be ended by reference to a provision which is common to all products of the International Law Commission, that is to the two conventions and the two draft of rules, but which is contrary to the general purpose of the law of state succession. All mentioned instruments contain a provision which states that the instruments are applied only in cases of succession which have occurred in accordance with international law. In other words, if a territorial change has not happened in accordance with international law, the rules of state succession could not be applied. Whether a change has happened in accordance with international law is frequently disputed question, which cannot be resolved swiftly. This provision might thus inhibit succession, and it might be detrimental in practice, in particular for economic well-being of local population, for commercial bodies and individuals. Much better solution would be to declare that the succession does not prejudice legality of territorial change, at least in respect of nationality, acquired rights, and archives. Thank you for your attention. Thank you.